Thank you. Any other board comments? We've seen none. Moving on to any comments from the public. Seeing no further board members or public comment, or is there, I'd like to take an amendment to this bill. The motion to approve the amendment from 6 to 12 months. So second. Second. Thank you. Any discussion on the amendment? And we'll close discussion on the amendment. Now we'll take a vote on the amendment to the bill.
I think Brian, you go with the second. No,
That's fine.
I'm just making sure. Michael Knight.
Aye.
Joel Martin.
Aye.
Rodney Cobos.
Aye.
Kelly Larson. Aye. Andy Guy.
Aye.
Alan Guy has excused absence. Jacob Lopez has excused absence. Diana Lowe.
Aye.
Lee Nutt.
Aye.
Steve Pinelli.
Aye.
Joseph Preciado.
Aye.
Jim Ruane.
Aye.
Thomas Ruiz.
Yeah.
Mary Tucker has an excused absence. Motion passes.
Thank you, Mr. Williams. Let's move on to agenda item 2, other bills related to CSLB and the contracting profession. Starting with item 2A, Assembly Bill 476 Gonzalez. A brief analysis of this bill can be found on page 125 of the materials. As you may remember, this bill would have required CSLB to establish a new licensure program for scrap metal copper sellers. The board voted to oppose this bill at the March quarterly board meeting. I am pleased to report that the licensing requirement was stricken from the bill on April 23rd, and this bill no longer has any impact to CSLB. As chair of the legislative committee, I authorize staff to let the author know that the board has removed its opposition. Because this bill no longer pertains to CSLB, there's no action required at this time. Are there any board member comments or questions on AB 476? Seeing none, is there any public comment on AB 476? All right, thank you. Let's move on to item 2B, Assembly Bill 485 Ortega. An analysis for this bill can be found in the board packet on page 126. AB 485 is currently pending referral by the Senate Rules Committee to a policy committee. Ms. May, can you provide a brief update?
Thank you, Member Barton. AB 485 was discussed at the April Legislative Committee meeting. This bill requires state agencies to deny a license or license renewal if the Labor Commissioner determines the licensee or applicant has an unsatisfied judgment related to the non-payment of wages. Existing law already authorizes the registrar to refuse to issue, reinstate, or renew a license or suspend a license for failure to resolve all outstanding final liabilities, including those owed to the Labor Commissioner. This bill would extend this requirement to other state agencies. I checked in with our counterparts at the California Architects Board and the Board for Professional Engineers, Land Surveyors, and Geologists to ask if the bill would present any significant workload or burden to their respective programs, and was advised that any additional workload would be unlikely. At the legislative committee meeting, members expressed that wage theft is prevalent in the construction industry and that the board may want to take a support position on this bill. Accordingly, staff recommends support. Back to you.
Thank you, Ms. May. Are there any board member comments or questions on AB 485?
I will just say anything to combat wage theft in the construction industry is important. I appreciate staff's recommendation and support.
Thank you, Chair Mark. Any other board members? Seeing no further board member comments or questions, let's take public comment. Are there any members of the public wanting to comment on AB 485? Seeing none, seeing no comments or questions, I would ask for a vote. Is there a motion on this bill? Motion.
Second.
Thank you. Mr. Williams, would you take the roll call vote, please?
Michael Mark.
Aye.
Joel Martin.
Aye.
Rodney Cobos.
Aye.
Miguel Galarza.
Aye.
Amanda Guy.
Aye.
Alan Guy has an excused absence. Jacob Lopez has an excused absence. Diana Lowe.
Aye.
Lee Nutt.
Aye.
Steve Pinelli.
Aye.
Joseph Preciado.
Aye.
Jim Ruane.
Aye.
Thomas Reeves,
Aye.
Mary Tiger as an excused absence, motion passes.
Let's move on to item 2C. Assembly Bill 742 Al Hawari. An analysis for this bill can be found in the board packet on page 128. AB 742 is currently pending referral by the Senate Rules Committee to a policy committee. Ms. Bay, can you provide a brief update?
Thank you, Member Barton. AB 742 requires programs under the Department of Consumer Affairs, including CSLB, to prioritize applicants who are descendants of American slaves as designated by a newly established Bureau for Descendants of American Slavery. The enactment of this bill is contingent upon the passage of another bill, SB 518 by Weber Pearson, which establishes the Bureau. AB 742 delays implementation until the Bureau can establish the certification process for descendants of American slaves. Staff believe the number of applicants under this bill would not be large, and costs to implement this legislation are minimal and absorbable within existing resources. Staff are recommending a support position as CSLB values efforts to encourage professional licensure by underrepresented populations. Back to you, Mr. Barton.
Thank you, Ms. May, and I also approve to recommend this bill. I would ask for any board member comments or questions on this, AB 742.
I had a question. What is this prioritizing? That, what does that actually mean? Prioritize.
The bill doesn't define it. The bill does not define the word prioritize.
No, we're interpreting it as expedite is how we would interpret that.
Okay. Yeah, and I believe the board doesn't deal with that. There'll be a separate committee or entity that will go through and verify.
They will determine what the
Right.
criteria is for certification,
Right.
and then it's the certification that folks will use to then apply with the SLP.
Right.
So we don't anticipate it'll be a large number of applicants.
Right.
And
So our approval would be based on a certification of some entity. Okay.
Yeah, we prioritize applications now. Somebody might come to California out of state, be doing a public work job with a lot of workers waiting to go to work. What really means to us is that would knock 3 weeks off the processing time in general. That's really what it is.
The reason I ask is I'm curious to if there's a way to measure that, and there's feedback we need to see if it's really working, or is it not? We come back and say that group that expected to get prioritized was like they have been prioritized.
Yeah, absolutely. We will keep track of it. And we want to provide effective service to all applicants. Some have to sit for the exam and they are comfortable waiting to continue to study, where others can, we will ask to be prioritized. And depending on the situation, we will do that. But Carol, that would be something that we would track.
Yes, it would. Right now, we also expedite military applications from veterans and from refugees who have certain statuses. And so we track all of those. We would just track this as well. If there's a certification, they would turn in their certification along with their application. We would prioritize their application, put them at the top of the list, get them processed quicker, get them contacted quicker, and get them moving towards their exams and posted quicker. And we would track those. So we can see, as you say, if it's having an impact.
Right. Thank you. Okay. Thank you. Are there any board member comments or questions on AB 742? Seeing none, let's take public comment. Are there any members of the public wanting to comment on AB 742? Seeing none, no. Would I therefore ask for a vote to approve on the motion on AB 742? Motion to approve.
Motion.
Second.
Second. Steve, no. Alex, second.
Yep.
Michael Mark,
Aye.
Joel Barton,
Aye.
Rodney Cobos.
Aye.
Gabby Larson. Aye. Amanda Cayo.
Aye.
Alan Guy as the excused absence, Jacob Lopez as the excused absence, Diana Love,
Aye.
Henry Nutt,
Aye.
Steve Pinelli.
Aye.
Joseph Pisciotto,
Aye.
Jim Romaine.
Aye.
Thomas Reeves,
Aye.
Jerry Tiger as the excused absence, motion passes.
Thank you, Mr. Williams. Let's move on to item 2D, Assembly Bill 1002 Gabriel, An analysis for this bill can be found in the board packet on page 130. AB 1002 is currently pending referral by the Senate Rules Committee to a policy committee. Registrar Pope, can you provide a brief update?
Yeah, this is an interesting bill as it relates to the Attorney General's office putting out a press release and talking about how they have a civil rights section, and we're taking this on, looking at a large contractor that allegedly is paying piecework, potentially below minimum wage, and how to effectively address that. When that press release went out, I received a lot of calls saying, what's Contractors Board doing? You're going to have any disclosure on the license? And so I reached out to our Attorney General, liaison, and asked if we could be part of the caption, if we could be part of this action. And he said yes, and we were added to it. But there was some question about how we would work together in the future. And so we look at this bill being very important because wage theft is very serious. CSLB does not have primary authority to investigate wage theft. We don't investigate wage theft. That's generally done by the Division of Labor Standards Enforcement, or and you have other state agencies that can become involved. But if they take it on, they file a 17-200 unfair business practice. We want to be part of that action, or be given the opportunity to be part of it, because we can help in the collection of those payments. We can suspend the license if they're not complied with. We would have a seat at the table if we want to have some type of injunctive relief issued on that licensee. Perhaps we want to petition the court to have the license revoked. This bill would allow us to do all of that while giving us still the opportunity to not be a part of it. We can sit out if we want. But it looks like a real positive for the construction industry. It's a positive for workers and the public, I think, and allowing the CSLB to officially be part of a 17-200 unfair business practice for wage theft.
Thank you, Registrar Pope. So the amendment would be to confirm CSLB's enforcement authority, correct?
Yes. Well, to confirm I guess that's the amendment, Rebecca. Okay.
Is that the statement, or is there more?
There's an amendment in the packet. If you
Okay.
want to take a look. But yeah, I would confirm that CSLB is the ultimate enforcer of its licensing. And the Attorney General's office has agreed, and the authors agreed to it. They've been working with us really nicely on the bill.
Just have one more thing. So there was some concern that the CSLB might not be identified as being the entity that would discipline a license. And we are. I don't know that the Attorney General's office has any authority to establish a website and discipline CSLB licensees. What happens is you have to petition the Superior Court through this action to order the registrar to take some type of action. We just want to be very clear in the bill that is what the intent is. And once this is an example, if the court was to order the license revoked, we have disciplinary guidelines that we follow as to when somebody can reapply. And so that's why I think we were looking at the amendment, just to be clear, the CSLB retains that authority that has been put in place over the years with industry and public support.
Thank you, Registrar Pope. Are there any board members' comments or questions on AB 1002?
Yes, really quick. It says in the legislation what the worker is entitled to. And so just for clarity's sake, is that a minimum wage standard? Or is that, what is, he's entitled to $5 an hour.
So yeah, that's the problem. I mean, that's what happens when you take the civil wage and penalty assessments. I know many of you here are very familiar with that. If you're doing public works, you got to pay prevailing wage. But there's other projects, and that also falls within here, by the way. The civil wage and penalty assessment can be addressed through this process. But if you're paying somebody based on a piecework basis to install drywall, as an example, and in doing that, they're not getting paid minimum wage, that would be the kind of thing that the Attorney General's office would look at. Generally, that would be Division of Labor Standards Enforcement. For something that's quite significant, they've taken a real interest in it. And it's unfortunate that Board Member Jacob Lopez is not here today, because it was the carpenters that were the investigators that resulted in this case that we're talking about. They made that finding and they brought it to the Attorney General's attention. They said, you know what? Yeah, we should take a hard look at this It's a wake-up call to the industry. You gotta at least pay your workers minimum wage.
Okay,
And it has to be based on an hourly wage.
so the trigger is minimum wage.
Yes, well,
Or wage order 16, if they're
we
providing
provide
violations.
The other question, does this legislation tie in with the workman's comp issue? Because clearly, if you don't have workman's comp, you don't have employees. You're saying,
well, there's two things that CSLB is a member of two task forces. One is the Joint Enforcement Strike Force, one is the Labor Enforcement Task Force. But for this purpose, it would tie into the Joint Enforcement Strike Force because the Department of Insurance is a member of that, very prominent member. So when one of the partners identifies wage theft, you may well have premium insurance fraud occurring. I don't know that that happened here. I'm not suggesting it did, but that would be something that would absolutely be looked at. Are they under-reporting their payroll for a lower premium? And that would fall under the Department of Insurance. So it all kind of comes together. But in a case like this, and why this can be important, is because it could ideally get these workers paid the money that they're owed and have a deterrent for future conduct. And so we want to make sure that we have disclosure on the license. And without being part of this, a contractor could be subject to this unfair business practice, and there would be no disclosure on the license. And so a awarding agency or somebody else looking at the license would have no idea that they had engaged in a civil wage penalty, a civil wage violation. And that's not good either. So it's a real upside to having the CSLB as part of this, to being on the caption, having a seat at the table, and making sure that the appropriate action is taken as it relates to the license.
Thank you. Any other board members, questions or comments?
To David, this seems like it, once you get on the table, it kind of grows into other areas, which is great because you're able to control it. Fees wise, or the amount of time that would be put into this, is there any kind of fees that the CSLB would be collecting from that contractor that was not paying and now, suspending his license and then going through all this steps that we would be doing? Is there any way to collect anything fees wise to circumvent what we would be paying out to the employees?
Yeah, thank you for mentioning that, because that's a real benefit to a 17200 action, is that you can recover your investigative cost. You absolutely can. And you also, there's civil penalties that are assessed. It can be $2,500 per violation. But when we've done these in the past, and it's been with, we have one with the Attorney General's office, but generally they're with local district attorneys, and we do get our investigative costs back, and they can be significant.
Thank you.
Thank you. Any other further board members, comments or questions? Seeing none, I'd like to take public comment. Are there any members of the public wanting to comment on AB 1002? Great. No further comments. I would ask for the question for a vote, a motion on AB 1002 with the amendment. I make the motion.
I'll second.
Thank you. Mr. Williams, would you take the roll call vote, please?
Michael Mark,
Aye.
Joel Burton,
Aye.
Rodney Phillips,
Aye.
Joe Calarza, aye, Amanda Guy, Alan Guy has an excuse absence, Jacob Lopez has an excuse absence, Diane Lund,
Aye.
Karina,
Aye.
Steve Pennell,
Aye.
Joseph Preciado,
Aye.
Jennifer Wayne,
Aye.
Thomas Reed,
Yes.
Aaron Cypher has an excuse absence, motion passes.
Thank you, Mr. Williams. Let's move on to item 2E, Assembly Bill 1327, Aguilar, Curry. An analysis with the bill can be found on the board packet on page 132, AB 1327. It's currently pending the Senate Judiciary Committee. Ms. May, can you provide a brief update?
AB 1327 is a bill the board voted to oppose unless amended at the March quarterly meeting. This bill would have allowed a consumer to cancel a home improvement contract via email or by telephone. While including additional ways to cancel a home improvement contract is good for consumers, the board expressed concerns that canceling by telephone does not provide a record of the cancellation, putting the consumer at a disadvantage. The author's office understood and agreed with our concerns and removed the provision allowing for contract cancellation by telephone. So accordingly, staff removed CSLB's opposition to the bill. We're bringing the bill back again today so that the board can deliberate on it. While the amendments removed the provision allowing for cancellation by telephone, it instead included a requirement that the home improvement contract contain a support line to aid consumers in completing the notice of cancellation. CSLB staff recognize that consumers, particularly seniors, may be inclined to call the contractor intending to cancel, not knowing that they need to cancel in writing. Because the definition of a support line is unclear, staff reached out to the author's office and asked the bill be amended to clarify that the home improvement contract includes the number of the contractor or the contractor's representative instead, and that the contractor or contractor's representative is to direct the consumer to the notice of cancellation in the contract to assist with filling it out. The analysis indicates a neutral position. Back to you, Member Barton.
Thank you, Ms. May. And I did read there was a lot of discussion amongst the board on this. So I would like to ask, are there any board member comments or questions on AB 1327? Discussion down. All right. Thank you very much. No further comments from the board. Move on to public comments. Are there any members of the public wanting to comment on AB 1327? I think so. I would like to ask for a vote. Is there a motion on AB 1327? Motion.
It's a motion. The motion to take a neutral.
Yeah, for a neutral position. So move, Mr. Nutt. Go, please. Thank you. Mr. Williams, would take the roll call vote, please.
Michael Martin,
Aye.
Joel Barton,
Aye.
Rodney Cobos,
Aye.
Miguel Galarza, Amanda Gayo, Alan Guy has an excuse absence. Jake Lopez has an excuse absence. Diana Love,
Aye.
Rena,
Aye.
Steve Pinelli,
Aye.
Joseph Preciado,
Aye.
Kimberly Wayne,
Aye.
Thomas Ruiz.
Aye.
Mary Tyker has an excuse absence. Motion passes.
Thank you, Mr. Williams. Let's move on to item 2F. Assembly Bill 1341 Hoover. An analysis of this bill can be found in the board packet on page 134. AB 1341 is currently pending in Senate Business and Professions Committee. Ms. May, can you provide a brief update?
AB 1341 provides that unlicensed practice in architecture, landscape architecture, engineering, geology, or geophysics, or land survey by a licensed contractor is cause for disciplinary action by CSLB. This bill will assist in preventing unlicensed practice of other licensed professions and is in line with CSLB's efforts to combat the underground economy. This bill does not require CSLB to investigate if unlicensed practice is occurring within another licensing program. However, CSLB understands the grave harm that unlicensed practice in general causes consumers, and its inclusion in contractors law may help draw attention to the issue. Staff recommends a support position. Back to you, Member Barton.
Thank you, Ms. May. Are there any board members' comments or questions on AB 134? Seeing none, let's take public comment. Are there any members of the public wanting to comment on AB 134? Seeing none, I would ask for a vote. Is there a motion on AB 1341? So moved. Second it.
And again, the motion is to support.
Yes.
Thank you.
Mr. Williams, would you take the roll call vote, please?
Michael Mark,
Aye.
Joel Barton,
Aye.
Rodney Cobos, Miguel Galarza,
Aye.
Amanda Gayo, Alan Guy has an excuse absence. Jacob Lopez has an excuse absence. Diana Love.
Aye.
Steve Pinelli. Aye. Joseph Preciado.
Aye.
Kimberly Wayne.
Aye.
Thomas Ruiz.
Aye.
Mary Tyker has an excuse absence. Motion passes.
Thank you, Mr. Williams. Let's move on to item 2G, Senate Bill 61 for tasing. An analysis for this bill can be found in the board packet on page 136. SB 61 is currently pending the Assembly Judiciary Committee. SB 61 was discussed at the April Legislative Committee meeting. The bill would limit the amount of a retention payment withheld from a private work of improvement to 5% of the payment or contract price similar to the amount withheld in public work contracts. This bill does not present any additional workload requirements to CSLB and may provide enhanced subcontractor solvency. Staff recommends a support position. And I would also stand in support of this bill because working and seeing the smaller subcontractors on a larger project, it does affect them greatly if their monetary payments are withheld. They have to pay supply houses, the workers. So just to make it in line with public works, I think would be applicable. So are there any other board member comments or questions on this bill? All right, seeing none, let's take public comment. Are there any members of the public wanting to comment on SB 61? All right, seeing none, is there a motion on SB 61? Thank you. Thank you, Mr. Williams. Would you please take the roll call vote?
Michael Mark,
Aye.
Joel Martin,
Aye.
Ivy Cobos,
Aye.
Kevin Garza, Amanda Kyle,
Aye.
Alan Guy has an excuse absence, Jacob Lopez has an excuse absence, Diana Love,
Aye.
Henry Nutt,
Aye.
Steve Pinelli,
Aye.
Joseph Preciado,
Aye.
Jim Ruane,
Aye.
Thomas Ruiz,
Aye.
Harry Tiger has an excuse absence, motion passes.
Thank you, Mr. Williams. Let's move on to item 2H. Senate Bill 456-E. An analysis for this bill can be found in the board packet on page 138. SB 456 is currently pending referral by the Assembly Rules Committee to a policy committee. Ms. May, can you provide a brief update?
Thank you. SB 456 establishes an exemption from licensure for artists who paint murals. The bill defines a mural as a unique work of fine art that is protected by copyright, trademark, label, or patent, and that is drawn or painted by hand directly upon an interior or exterior wall or ceiling fixture or other appurtenances of a building or structure. Mural would not include wall signs. Staff recommended neutral position on this bill. The author's staff have been working with CSLB to craft the exemption to be clear for the public and staff to understand. Further, no consumer or public harm caused by muralists has been established, and this bill does not create additional workload for CSLB. Back to you, Member Park.
Thank you, Ms. May. Are there any board member comments or questions on SB 456?
I have a question. Maybe you have the answer for this. In materials, is scaffolding considered materials?
Well, scaffolding would be included in the work performed by a muralist.
Okay.
Absolutely.
Just wanted to make sure, because when I saw the value of $1,000, if it's a big mural, scaffolding is definitely going to be over $1,000. So I just want to make sure we're on the same page on that.
Yeah, and I think the muralists that we're talking about, the contracts that I've seen are well over $1,000.
Thank you for that. Any other board member questions or comments? All right, seeing none. Oh, is there a question?
I was just gonna mention that scaffolding is in 7026. I don't know if that plays a factor here. The erection of scaffolding falls within the definition of a contractor.
No, but in order to do these murals, if you're doing it above, let's say a second story, you need a scaffold.
Right.
And that's part of the contract. I mean, there's lots of trades that would use a scaffold. The electricians use them quite often. So it's part of the contract. This isn't about whether to install a scaffold, you need a license. It's about muralists who would use scaffold as part of performing the trade.
Part of the larger scope.
Yes.
Yeah, and I think what Mr. Chiminski's possibly alluding to is they would have another scaffolding company do that. So it wouldn't be a muralist. And correct me if I'm wrong, a muralist probably would not be qualified to erect a scaffold. You'd have to have a licensed contractor or safety erect a scaffold. Right? That's kind of the gist, I would think.
Well, and you might hire someone to install your scaffold, but if you're the awarding agency for this, that's not generally going to be broken out from what I've seen. If you're hiring somebody to put a mural on a building, and they're the ones that have to do that. They may subcontract to somebody to install the scaffold. But I've not seen where the awarding agency would hire a scaffold company separate from the muralist. That's not that couldn't happen. I just haven't seen it.
The reason why I was asking was that what you're saying is if I'm the building owner and you're the muralist, and the muralist turns around and said, you get me the scaffolding, you get it all set up, and you pay for it. That's not part of my material. That's not my cost. My cost is just the paint, the design, and doing the work and the labor. So that cost could be offset. So I'm just saying if it's a job that has the scaffolding as part of that job, at that point, they should have to be licensed.
Yeah.
Because they need to know the safety requirements of being on scaffolding and everything else, and that's part of the license, right? So with no license, then you don't have that.
So question for Rebecca, you're not aware of any discussion to exclude scaffolding as part of these contracts?
And maybe this is a question then, the current license required for this, what is it again?
It falls under the C-33, painting and decorating classification.
And obviously, I know we've had a lot of public comments in the past regarding muralists and the underground economy in this. Staff is recommending a neutral position on this.
You know, a neutral position, because if you look at the history of the C-33, till recently, this has not been an area that CSLB has received complaints. So people that might be doing artwork on an electrical box or something, it just hasn't really come to the CSLB's attention until recently. I'm aware that we previously, I know Steve was looking at me and saying, well, probably 2 years ago, we started getting complaints about it, right, Steve? And he was like, and so trying to figure out how to handle it. Because we have awarding agencies, cities and counties that are hiring muralists that are not licensed.
Right.
And when we look at our regulation that adopted the C-33, it appears to fall within that C-33 painting and decorating classification. And so that's what this bill is about. It would be to exempt muralists from CSLB licensure.
Interesting. Any other board member comments?
I think what's difficult is you can kind of see both sides, or maybe potentially why it would need exemption and why there's a license in place. It's because there are some large muralist projects that the consumers have to go buy these projects on the side of a building, and you want someone who's licensed. If there is something that goes wrong, it could be harm, right? So that's kind of the recourse. And if awarding bodies are hiring currently muralists who are unlicensed, then that's an issue. Was there any clarification in the bill that shows exactly what is the scope that would be exempted? Like, is it like really in detail? Does my question make sense?
Yeah, it's pretty detailed to the application of paint to the list.
But that could mean anything,
Yeah, it doesn't specify.
like a size, like 5x5, 10x10. So does that part is, if per your comment, if anything, paint to surface would mean painting the building.
Well, can you read, or I'll do it, exactly what the bill says? This bill defines a mural as, I think we need to read that exactly. I could get up to do it. But we had a lot of discussions on this, and we're talking about copywriting. It says the bill defines a mural as a unique work of fine art that is protected by copyright, trademark, label, or patent that is drawn or painted by hand directly upon an interior, exterior wall or ceiling. That's specifically what we're talking about. If we're not talking about, getting a roller. I was a painting contractor, by the way. Getting a roller and painting the wall. It's just like putting artwork on a structure.
Well, that could be, that's to my question exactly. Thank you for helping to clarify that.
Any other board member comments or questions?
How does CSLB, if it's really coming from cities and counties, how are we looking at enforcement of this? If this, I know it's happening now, widespread, and we've talked about it through the cities that are contacting me. I think it's I don't know if it's gonna be able to be enforced, just with all the public art programs that are already in place.
We've reached out, Steve boldly sent letters, I think, and we've taken a stance that was to whether the license is generally going to be required today. And the cities and counties that we've interacted with don't want to require the license. And so that, I think, is the basis for this bill. Because if we're not going to require a license, it needs to be very specific as to what work can be done without the license. I think if someone does that, Eric, and then it would exempt it, so there'd be no question. We do have complaints pending now regarding this, that we're waiting for a little direction to see how the board looks at it. Our thought on those complaints is to continue to educate not only the unlicensed muralists, but the awarding agency to the current license requirement. Let them know about this pending bill. Steve, do you want to add anything to that?
Well, we've received complaints, leads from individuals that are aware of these projects. So that's how we're getting involved in it. And they vary. I mean, some are more than just painting. It can be, for example, one of the projects was in Sacramento was called it the flip-flop case because it was a giant replica of a flip-flop at a swimming pool. So it's more than just painting what we've been dealing with.
So that's a physical, like, wasn't this art? It was, I mean,
It's a sculpture.
sculpture. Okay.
Yeah.
The one thing reason why I'm harping on this is I can't find anybody to come in and paint a bathroom for under $500. And I find it very difficult to find out somebody that's doing a mural for less than $1,000. I mean, they're starving artists, as we all know, but I guarantee you, if they're doing a mural that's 10 by 10 or 5 by 5, it's going to cost more than $1,000. And I find it very hard to believe that materials, labor is going to be less than $1,000 for somebody that's doing a mural that sometimes is, 10 by 10 or 20 by 20 on the side of a wall or business. So
Yeah.
that's it.
Well, so more clarification, this bill, I mean, right now, if the work was valued at less than $1,000, there would not be a license requirement, but this will relate to the larger projects. They could be tens of thousands of dollars. It's gonna exempt what this bill says fine art. So it's not about going and painting the interior of this room here, the outside of this building. This is putting artwork on a structure and exempting it from licensure. And it would exempt from licensure a contract that could be $100,000. We haven't seen, I'm aware of any consumer harm that's occurred like muralist. So that's been something else that we've looked at.
Correct.
Any other board members, questions or comments? Right, seeing none.
I think what's just difficult and unfortunately why for this specific bill, they did just not go into more detail of what, like, it could be $1 million a painting. And at that point, there's considerable amount of time on that project. So if you're just exempting everything, like full boat, it's hard for us to like actually provide some insight on this because, someone mentioned workers' comp. If something's $100,000 of painting on the side of a building, scaffolds involved, multiple people's involved, just members of the public could be, and that's why for awarding bodies that it's considered, I believe, a public works currently, right? I would think so. So it's hard without the author really putting more detail and just exempting all work that's what makes it a little bit difficult. So, and that's why, I guess that's why there's a neutral position from staff is because there's not enough information.
Make a motion and not support.
Yeah, but we'll do that after public comments, so. Any other board members, questions or comments? Okay, and with that, we'd like to open it to public comment, and I'd like to limit public comment to 3 minutes. And Mr. Williams, would you be the timekeeper, please?
Yes.
Thank you.
Good morning. My name is Deanna Sessoms. I'm the Monterey Bay Public Affairs Manager for the League of California Cities, which is a proud co-sponsor of SB 456. Cal Cities recognizes and respects the critical role that this board plays in ensuring public safety and professional standards in building trades. That's why this bill is crafted with care and why the bill's sponsors have been in direct contact with the CSLB staff from the very beginning, even accepting amendments to address initial concerns. SB 456 does not create a broad exemption or seek to undermine regulatory authority. All safety regulations remain in place. It simply restores long-standing practices by clarifying that muralists, whose work is artistic, not structural, should not be treated as contractors under the current framework. In 2023, cities began receiving public notices from the CSLB board stating that muralists fall under the definition of a contractor in state law. This interpretation has not been applied to muralists before, and it's causing serious confusion and disruption for public art across our state. We've seen the effects firsthand. In Stockton, contracts with selected muralists were canceled. In Palo Alto, over $60,000 in plain murals have been paused out of concern that hiring unlicensed artists could violate state law. Cities across California are holding back on murals, not because the work isn't valuable, but because of uncertainty around this new legal risk. SB 456 offers a clear and very narrow fix. It simply adds muralists to the list of professions that are not subject to contractor licensing requirements. It recognizes that muralists are not performing construction work. They're not altering structures or installing protective coatings. They're creating public art that reflects community identity, that inspires pride, that supports local economies, and that contributes to safer, more vibrant neighborhoods. Importantly, SB 456 does not remove any health or safety regulations. Muralists must comply with all relevant OSHA standards, secure permits where required, and meet the terms of their contracts. This bill does not exempt them from any of those responsibilities. It only ensures that they are not swept into a licensing system that was never designed for their line of work. SB 456 does not create a loophole. It actually closes a loophole. It restores clarity, it preserves the integrity of our licensing system, and it protects the ability of cities to commission muralists in a safe and lawful way. For all these reasons, we respectfully urge your support of SB 456 to ensure that artists can continue doing what they've always done, bringing beauty, identity, and meaning to the public spaces that we all share.
Without objection from the board, I'd like to increase the public comment to 5 minutes. Is that okay with the board? Thank you.
Good morning. My name is Natasha Trevesa, and I'm a local artist born and raised in Monterey. And I'm co-founder of a mural company called Magnified Murals. And we've been painting murals professionally within and beyond the county since 2020.
Hi, my name is Jessica Soriano, and I am a local artist who has been painting murals professionally since 2019.
The process of creating a mural is long and impactful. Murals are a collaborative effort between the artist and the community that takes time, limit creativity, and patience. These works of art are more than just being on a wall. They are opportunities for cultural impact, community engagement, and education beyond the arts, often including scientific, historical, geographical, and even mathematical education.
In counties throughout the state, public art policies ensure that funding is allocated to collaborate with artists on installing murals on newly constructed buildings. While the city of Monterey has yet to write its own public arts policy, requiring muralists to apply and comply with contractor state law license law discourages the further development of public art programming within cities like ours.
For muralists like us, a portion of our budget and timeline is often allocated towards community engagement, since most projects can include requirements for community input before finalizing a mural design. Along with that, many of the contracts we sign obligate us to operate through general liability insurance, obtain site-specific business license, zoning permits, background checks, machine operating permits, and traffic permits. That is to say, muralists are already going through great lengths to ensure safe and professional environment throughout the entire process. If we were to add a contractor's license to the list of requirements needed for the mural, we would have to reallocate funds that are meant for community engagement. In other words, this reduces our community impact.
By passing SB 456, there are opportunities for youth and emerging artists to become involved within the communities and create meaningful public art. All in all, we feel that muralists should be exempt from Code Section 7026 because it adds another bureaucratic layer. This will cause delays and reallocation of already limited funding, which negatively impacts our ability to coordinate time-sensitive events related to the mural and risks the overall success of the project.
We want to express our gratitude to arts advocates of the League of California Cities and Arts Council for Monterey County. Please support Senate Bill 456 and exempting muralists from comprehensive license. Thank you for your time.
Okay. Good morning, everyone. My name is Jennifer Lopez. Yes, get your jokes out now. I'm here today in a unique capacity as an artist and performer myself, someone you might find on stage or even on a film set with over 11 years of experience. I profoundly understand the drive to create. I'm also speaking on behalf of the dedicated C33 painting and decorating contractor paint pros represented here by its owner, Kyler Hernandez. We're here to address Senate Bill 456 directly to you, the California State License Board. We deeply respect your critical work in upholding the integrity of California construction industry, and most importantly, in protecting the health, safety, and general welfare of the public. That mission is exactly why we urge you to consider the profound implications of this bill. Our opposition is not isolated. Licensed contractors across the North State also stand against this bill. We've even spoken to recent licensed C33 muralists who voiced direct concerns about its safety, implications, and more than anything, the general public was not adequately made aware of this bill. They truly knew its implications. We believe there would be far more stronger in the fight. Sorry, you seem sure. Because we are very passionate about this. We absolutely understand and share this passion for promoting public art. This bill in its current form fundamentally undermines the integrity of contractors' licenses, introduces critical safety risks, and creates an unfair playing field for established licensed professional muralists in the state of California. We simply cannot let well-intended initiatives compromise the very standards to our task to uphold. Members of the board, you understand better than anyone what a C30 license entails. It is not a trivial hurdle. It's a rigorous process that demands dedication, expertise, and substantial investment of both time and resources. To earn this license, contractors must demonstrate at least 4 years of journeyman and level experience, pass 2 comprehensive state exams, one on their specific trade and another on business and law, undergo criminal background checks, secure a $25,000 contractor bond, and maintain general liability and workers' compensation insurance. These requirements ensure that a licensed contractor possesses not only the skill to perform the work with precision and quality, but also the essential knowledge of business practices, legal compliance, and critical safety protocols that both protect workers and public. SB 456 proposes that directly passes these requirements for muralists, artists as it now broadly terms in the bill. This essentially creates a carve-out that declares if you call it art, if you call yourself an artist, you don't need to meet the same stringent standards of someone painting a building. This is a critical flaw. Consider this. The current law already mandates a contractor's license for any painting project exceeding a mere $1,000 value. This threshold exists precisely because even smaller projects involve potential risk and require a layer of professional accountability. SB 456 completely disregards this established framework, eliminating the need for any license regarding the project size and complexity, simply by making the work as art. This direct exemption appears to serve the interests of some already existing and well-established muralists who simply wish to bypass contractors' laws rather than genuinely open new doors for aspiring talent. This directly devalues the hard-earned licenses of C33 contractors who adhere to these standards. Many professional muralists are indeed artists who have chosen to obtain their licenses, the C33 license, understanding its paramount importance for ensuring safety, quality, and professionalism in their craft. This bill broadly uses the term art and artist, suggests that specifically specifies knowledge and safety training are unnecessary for muralist work, and a notion that is fundamentally flawed and contradicts your board's core principles. Our deepest concern, however, revolves around public safety. Murals, particularly large-scale pieces on commercial buildings or public infrastructures, are far more than just canvases in a studio. They are complex construction projects. They often involve working at significant heights, utilizing specialized scaffolding, booms, lifts, or even cranes. This work can take place near electrical lines in high-traffic public spaces or involve the handling of various chemicals and materials, and they don't even know the rules on how to waste materials about that. Unlicensed individuals, while undoubtedly talented artists, simply won't have the mandated safety training, OSHA compliance knowledge, or require insurance that licensed contractors do. This rule removes a critical layer of mandated safety oversight, leaving a dangerous void. Who is liable in cases of accidents, be it falls from heights, chemical exposure impacting workers of the public, or property damage resulting from improper equipment use or site management when an unlicensed artist is involved? This bill opens the door to immense liability for property owners, project sponsors, and potentially even the state if an accident occurs on a public commissioned mural project. Licensed C-33 contractors must adhere to stringent safety regulations, conduct thorough risk assessments, and carry appropriate insurance for precisely these reasons. The beauty of art should never, what?
15 seconds.
Great. The beauty of art should never come at a cost of this. And I hope that you guys understand and reconsider your thoughts on this bill. This allows them to unfairly underbid legitimate licensed businesses, including the talent. His business is here to support these artists and these up-and-coming people and wants to create programs that they can work underneath them to earn this. He's working with artists now in our local area. We drove 5 hours overnight to be here today because we strongly believe that our city is significantly being affected by this. And we think that if they want to have their license, they need to do it properly. And we know people like Max Follett in Sonoma County. There's a few other names that I can mention, but they all have their licenses. Our C-33 contractors. So I'm here today speaking on behalf of him. I'm a little nervous, a little tired, but I thank you for your time. Thank you very much.
Councilman Campbell, am I allowed to ask a question of the speaker?
Yes.
Absolutely. Just a quick question if I could. So this would not limit, let's say, an artist, non-licensed. They could become an employee of a licensed artist, right?
Basically what we're trying to do and start programs in our city is basically having even college students, young up and coming artists work under a C-33 contractor. You can even do your work. I don't know if you want to even say on it, but we're basically, we're
providing the proper steps that they should be taking to do this work, the correct avenue to do this practice.
I've been a part of film production. I have been a part of people that have been a part of the Alec Baldwin shooting and the woman that was hit by the train. And I know for an absolute fact that in the Alec Baldwin shooting, I knew on the first day that it was the armorer. And I told him that and I was screaming in our house, why would they arrest this woman? And it's because she was not properly trained. Her father was an armorer, which gave her the job. And if she had known enough that there were real live rounds in that woman would not be dead today. And I don't want to see somebody falling off a scaffolding and dying, or somebody who doesn't know the proper laws. And we run into these issues because we were willing to just have a bill that people just wanted to be neutral on, or who thought to uphold. This is their mission statement. I looked it up and I found that mission statement, and when I saw that, this needs to be upheld. That is the point here. I am an emotional artist. I'm a performer. I've represented artists and I've represented visual artists. I don't want to see my friends and my family getting hurt. Thank you.
Thank you very much. Any other comments from the public?
I'm Jackie Atchison. I'm the Executive Director of the Arts Council for Monterey County, or the county's official art agency. I want to welcome you all to Monterey. Let's get a chance to enjoy our beautiful city. Since the beginning of the pandemic, we've seen a large increase in murals as it was a project that could be done outside and keep our artists working and getting paid when other projects and programs were canceled. A few years ago, Monterey County was fortunate to be awarded funding from Caltrans for the Clean California State Highway Beautification Program for 3 large murals on Highway 101 underpass in East Salinas. All the artists selected were California residents. But this is a new process for Caltrans, a state agency. This is really a pilot project and a learning experience for all of us and the artists. During this process, our Caltrans contact learned that EIR training was required. And there was an application fee for each artist, not just the main artist, each artist of $400. And then when the project was delayed, due to no fault of the artist, they had to extend their registration again for another $400. And this really isn't affordable to most artists, especially on smaller projects. Mural making is a creative process, as mentioned, protected as original artistic expression under copyright, distinct from trade work like painting houses. Licensing was not intended for artists carrying out visual art projects. Though they do carry liability insurance, if they work under our organization, they're covered under workers' comp and liability, and they follow Cal OSHA laws. This work is an artistic expression and does not provide structural integrity to buildings. Murals don't only beautify public spaces, they celebrate local culture and history, foster connection and dialogue, support local artists, and create a sense of belonging. They're also a powerful tool for transforming communities. We recently completed a large mural in town of Chular, celebrating the Bracero, well, honoring this, the Bracero farm workers who were killed in a bus train accident back in 1963. We have a huge community outpouring for that. Hundreds of the survivors, families of survivors attended the ribbon cutting and thanked the artists for such a meaningful memorial to their community. So the exemption for SB 456 aligns policy with the California Arts Preservation Act and acknowledge murals as valuable cultural assets. It removes barriers for artists, ensuring communities can continue to create public art that reflects identity, promotes cohesion, and enhances local economies. So we appreciate your support of SB 456. Thank you all.
Thank you.
Good morning, and thank you for the opportunity to speak. My name is Jesse Mordes, and I am the Executive Director of Youth Arts Collective. We are a nonprofit arts organization based here in downtown Monterey. I'm also a lifelong resident of Monterey County and a proud former student of YAC myself. At Youth Arts Collective, we mentor the next generation of young artists, many of whom dream of turning their creative passion into a career. One of the most inspiring ways we've seen this come to life is through public art, especially mural projects. These murals don't just beautify neighborhoods, they give artists an opportunity to contribute to their community, to be seen, and to make a living through their work. I'm here today in strong support of SB 456, requiring muralists to hold a contractor's license when they are not performing construction work or altering structural integrity creates a significant and unnecessary barrier. At Youth Arts Collective, we hire professional artists to serve as mentors for our students. We choose these mentors for their artistic talent, their commitment to their craft, and their ability to inspire the next generation. Our artist mentors, some of whom have joined me today, serve as living proof to our students that a career in the arts is not only possible, but deeply impactful. They demonstrate that success can take many forms, including as professional muralists, whose work provides meaningful service to the community by transforming public spaces, celebrating local identity, and civic pride. And personally, I grew up in the Salinas area, and for many years, our community faced stereotypes and ridicule. But it was over time it was murals, works of art created by local artists that helped tell our story with pride and dignity. These murals have become cultural landmarks, and they've helped change how people see our communities and how we see ourselves. I believe that by not passing SB 486, we risk silencing stories. We risk denying talented artists the chance to work legally in their own communities, and we risk sending the wrong message to the next generation of artists and community companies. I believe that SB 456 doesn't remove safety standards. It simply clarifies that murals are art, not construction. This still restores longstanding practice and ensures that public art can continue to thrive across California. Thank you for your time and considering this important measure.
Thank you.